Investigator is on the stand right now, Jamie Nolan, and we are looking here in the trial, in the Hammer Hitman murder trial, Florida versus the state of Rogers. And you can see they have a sidebar, and all the attorneys are present at the front of the courtroom where they're talking to the judge. We don't know what that sidebar is about. Let's see if we can talk with our guest now as we are looking at what's going on. So first of all, welcome to both of you. Thomas Flugum, criminal defense attorney. Crystal Ramirez, also criminal defense attorney. I really appreciate you being here with us today. Let's jump right into Rogers. So yesterday, 5 witnesses were presented by the state. And the thing I noticed, and I want to get your opinion as defense attorneys, the state started with the first witness, who was the sister of the victim, this Dr. Severs, that the community knew and loved by all accounts. And what's the point? Let me start with you, Thomas. What's the point in your mind of the prosecution starting with somebody who doesn't know what happened, but rather knows the victim?
Well, part of the thing when you start a trial is you want to introduce all the parties and get the jury to have a good sense of who the people were involved. In a case like this, they start with somebody like the sister to give a background on the familial relationship, who she is as a person, connections that she has to other people in the community, that type of thing, so that you humanize her and give the jury a reason to care about what's going on.
Right, absolutely. That makes good sense. So what's next? If you were the prosecutor, what would you do next in terms of the witnesses and the evidence? We know that they started chronologically. Is that, in your experience, one of the best ways for the state first to proceed with laying out the evidence?
Definitely, because you have to establish a story, and you definitely want to make it easy enough for the jury to follow along. So you start with, establishing who the victim is or was, to be clear, who the victim was, and then you kind of go in order of how the events unfolded.
And so as a defense attorney, how do you challenge that? What do you do to say, okay, I'm listening to these witnesses. So far, there's been very little cross-examination. On some of the witnesses, there's been no cross-examination. Let me start with you. Is this typical? Would you do the same thing if it were you?
Yes, because as defense, you have to be aware of your perception to the jury. And so you don't necessarily need to cross every witness.
And what would you do in terms of, especially when you're hearing about the victim with the first witness, the sister, is there any reason you can think of as a defense attorney that you would want to cross-examine that witness?
Well, I think it depends. What can you get out of her, right? Is there anything that helps the defense that you can get out of the victim's sister? And in a case like this, the victim's sister doesn't know a whole lot about the background and what actually happened. The whole purpose that the prosecutor's putting her up, again, is just to give a background into who the victim was as a person. And so, if you attack that person with full gusto, you might hurt yourself and your client because you look like you're trying to pick on somebody who doesn't necessarily know a whole lot about the case. It's a person with a close relationship to the victim, maybe the closest relationship out of anybody that they're going to present at trial. And so if you jump out and beat that person up from moment number 1, you're setting yourself and your client back a little bit, I think.
Okay, that's an excellent point. And let me ask you both this question. So we know death penalty case. So obviously the state and the defense had the opportunity to ask these jurors questions one at a time to determine where they might stand on the death penalty to then select the jurors. So my question is, how much do you all think, as a defense attorney, the jurors remember from that questioning and their first impression of you? Because that's their first look at you as an attorney versus when you actually start presenting evidence and cross-examining. Let me start with you, if I could.
Well, and you always want to have your best foot forward with jury selection because that is the most important part of the trial. I mean, those are the people who are going to be making the final decision as to guilt or innocence, or to your point, death or not death. And so having a good impression with them from the start of jury selection all the way through the trial is essential. Whether we like it or not as an attorney, we project our client, and we are taken as a, representative, obviously, of that person. And so the members of the jury, we are the mouthpiece for our client, and they're taking what we say as an extension of what our client would say. And so it's essentially important that we always have our best foot forward.
Yeah, excellent point. So what we're going to do, we're going to take a quick break. I just want to bring you up to speed. They're in sidebar still. We're going to bring you right back into court live when we come back here on Court TV. Now, don't forget, the clock at the bottom of your screen is ticking, which means we could get a verdict any minute in Florida versus Benoit and Garcia. Don't go away. You're watching Court TV live. as I mentioned earlier, we heard a knock on the door. Now, this is the Florida versus Garcia Magbanua case, and here's what's happening. The judge did answer the question. We're going to go right to court to see what the judge's response was to the jury question this morning.
8 o'clock. We have a question. I believe everybody was given a copy of the question, were they not?
Yes, sir.
Everybody got it?
Yes, sir.
All right. For the record, the question is, can you be a principal to premeditation if you do not premeditate it yourself? I've written a proposed answer. Here y'all's comments. Dear jurors, again, you're asking me to apply the facts to the law. On pages 2 and 3, I have defined first-degree premeditated murder. On pages 5 and 6, I have defined principles. If you're confused by those definitions, please let me help clear up your confusion. However, I cannot answer hypothetical questions. I can only answer legal questions. I'll hear your comments.
Acceptable.
Yeah.
Your Honor, I would add in the independent, I would also make a reference to the Independent Act, because that's what it is, that's what it appears pragmatically that the jurors are asking. Can you be a principal to premeditation if you do not premeditate it yourself? That called, in my reading of it, that appears to be the exact position of an independent act. That this person, in their hypothetical, did an independent act.
If you want me to mention independent act, I
Yes,
don't
Judge.
have a problem. I'm not sure that the question is that clear that that's what they're asking.
I would ask it
But
respect to that.
that's one of the instructions. I don't have any problem referring to it also. Magbanua.
Your Honor, Ms. McDonald's position would be that the response should be that the jury needs to rely on the law that is presented to them in the instructions, and that's it.
That's what I've done in a little bit of a long-winded way. Try to, I haven't told them anything else really. I think we need to at least be acknowledging that we're trying to answer their questions. I agree with, in essence, what you're saying, but I don't think I've done anything else other than refer them back to the jury instructions. But I think it's the second time. I think it is important that I tell them that I cannot answer hypotheticals. I think that needs to be done because this is kind of just a veiled hypothetical. I think we need to get it across that I cannot answer hypotheticals, or I guess we're going to continue to get them. So give me a minute. Other than any specific objection to what I've said?
No, Your Honor.
All right. State have a problem with me mentioning Independent Act also.
We request that it not be, they're not talking about Independent Act, they're talking about premeditation. It seems pretty clear that they're having issues with that portion of.
I think an argument can be made that their hypothetical would involve Independent Act, so I don't think it hurts to mention it. Again, all I'm doing is referring them back to the jury instructions. Give me a minute.
All right, so here you have heard the judge directly from his mouth that he has said, I am not going to answer hypotheticals. I'm going to instruct the jury. I can't do that. I want to bring back in my two special guests, Thomas and Crystal, defense attorneys. Let's talk about this. So, I was kind of making some commentary as we were watching because I thought the jury's done this. They did this yesterday and they asked some questions that the judge said, I can't apply the facts to the law for you. You need to do it. So let me start with you, Crystal. What did you think, first of all, of the question and whether or not can you be a principal to premeditate it if you don't premeditate yourself? What do you think of that kind of question from the jury?
It kind of shows where the jury's going. But the problem is, as the judge continues to state, we can't answer a hypothetical question. You have to apply the law to the facts, and you have to be able to identify the law. So where the judge is, hey, I'm going to refer you to where this law is, you want to consider that law, and you jury are responsible for that task. We can't do it for you.
And it, to me, is a completely appropriate instruction because it is true that's the jury's job, not the judge's job, and he certainly cannot apply any facts or answer any hypotheticals. But let's talk about part two. So what he does say and said in what we just watched is, okay, I'm going to tell them where to find the definition of premeditated. That's pages 2 and 3. And I'm also going to tell them to find the definition of principle on pages 5 to 6. So is that something that you think, what did you think of that response by the court?
I mean, I think it's always best of the court to just refer back to the agreed to jury instructions that the attorneys have come to.
Okay, great. We're going to talk more, but right now we're going to go back to court live. We're not going to want to miss it.
Defined independent act. If you're confused by those definitions, please let me help clear up your confusion. However, I cannot answer hypothetical questions. I can only answer legal questions. Any additional objection to that explanation?
No, sir. No, sir.
No, Your Honor.
All right, I'll give that to the jury. You will proceed.
Let's go upstairs and look at the next.
So let's talk a little bit more about that. We're just showing, and you can see what the judge came out as his final set of answer that he's going to give to the jurors. So let me ask you all this. I'm going to change this back, go backwards a little bit, and then go back forwards. So a judge, like in this case, always says the question to the attorneys, they're in the courtroom, and this is what I think my answer is going to be. What is the reason? Let's talk about for the viewers, and I'm going to ask you if you would, Crystal, what is the reason that the judge wants the attorneys to weigh in on what the judge intends to say to the jury?
Because what goes back to the jury is extremely important, and you don't want to appear impartial. So this gives both sides an opportunity to consider what goes back and make an argument whether or not it's proper, considering their whatever perspective they may have.
All right, and Thomas, if they do object, say you're an attorney on the case and you object to something the judge wants to say, is that something that's appealable down the road?
Absolutely. I mean, the trial and the decision ends today, the process for these two defendants doesn't end today. Whatever the decision is today, there's likely going to be appeals. And so every time an attorney makes an objection or, if the judge rules against the defense attorney, it creates an ability for us to have that decision reviewed later on. I think the judge is doing everything that he can to prevent that avenue down the road. So he made sure everybody was heard on the issue and took everybody's opinions when he's making that decision to do the instruction.
Absolutely. And the other piece of this, I'm fascinated by these questions this jury is asking because, again, we are looking at our clock, 5 hours, 12 minutes into the deliberations in this case with these two defendants accused of murdering law professor. And here's where I am with this. The questions are very detail-oriented about principle again, but I also do feel like they're asking about the facts and a hypothetical, and they want help inching along towards how does this apply and how can we apply this to the law. I do feel like it's crossing a little bit of a line and doing some of their job, but I want your opinions. Let me start, Crystal, with you.
Whether or not it's crossing the line.
Yes, yeah. I mean, yes, your opinion as to what the questions are they're asking. Are they appropriate questions? Do you feel like the jury is struggling with how to actually apply facts to law?
It appears to be. It appears as if the jury is one, you can appreciate that they're taking the time to go through the evidence and really consider what's going on. So you definitely appreciate that. But it definitely, leads you to believe that there is a struggle there because it's the second hypothetical. So they, presented one before, came back, and now here's another one. So definitely it kind of, if you can kind of, gauge and get a gauge of what's going on in the room, it's that they are definitely struggling with, this task.
And let's talk about the facts in the case. So we've talked about, you know, that we have Wendy Adelson, who's the ex-wife of the law professor. You have her mother-in-law. There were some emails that are not good in my opinion, right, for the defense, because they are certainly talking about the husband, a victim in this case, and the things that she thought should happen to him or how to take care of him, and telling her daughter, this is what you need to do. Then that's one group, and the prosecution has said, and that's the theory of the case, is they weren't involved at all in this, right? So they're not involved in this crime. Rather, what we have is a Prius who went to the home. We know that the two individuals driving that were the defendant in this case, Garcia, but also Luis Rivera. Luis Rivera, as we know, is one who testified in this case. He did get a deal. He testified and said, nope, Garcia was the one. So all of those facts, how hard are those? And let me start with you, Thomas. When you have a lot of facts like that, really there's been a lot thrown at the wall for the jury to decide, how difficult does that make a jury's job?
I think it's extremely difficult, especially in a unique case like this, where it seems like the people potentially driving the bus haven't been indicted and aren't involved in the trial at all. And so the state is trying to loop those people in without charging them because there's a clear lack of motive or relationship between the victim and the killers. And so the state has to connect those dots somehow. And I think from the jury's perspective, it's got to be difficult to be able to link people in that weren't charged with the crime and haven't faced any prosecution so far. You know, but the flip side is the state's theory relies on that evidence. And so that's got to be a difficult decision.
Yeah, I agree. There's so many facts in this case, and there's a lot of information for this jury to absorb. Now, we are going to have to take a short break, but you are not going to want to miss any of Court TV Live. Two things we're covering: Verdict Watch. We're going to continue on that, let you know as soon as we hear anything else out of that jury in the state of Florida. And then we're going to return to the case of Jimmy Ray Rogers out of the state of Florida as well, right after this quick break, live here on Court TV.
Everything you love about Court TV is now a podcast.
Let's figure this whole thing out.
Yes.
Join Vinny Politan and Seema Iyer for this week's new episode of the Court TV podcast, available now wherever you listen to podcasts.
This is Court TV.
The network designed for true crime.
Not justice! No peace!
Is there reasonable doubt? We'll find out.
This is Court TV.
Your front row seat
To justice.
Welcome back to Court TV Live. I'm Ashley Wilcott. Happy that you are joining us today. Two things I want to make you aware of. The first is, in Florida versus Garcia and Magbanua, the jury right out of the chutes came up with a question that they wanted to ask. The judge has responded to that question and said, listen, you have to look at the definitions you've been provided of premeditated and principal, and I cannot answer a hypothetical as the judge. So he has sent that back to the jury. Look at your clock. I'm looking at it now. We're at 5 hours 19. You're going to want to continue to watch that as we wait to hear when a verdict is forthcoming in that case, and we'll go right back to that when we have that. In the meantime, we are covering Florida versus Jimmy Ray Rogers. This is in Florida, obviously, and Detective Nolan is the investigator on this case. He is the sixth witness, and he's currently being cross-examined. Let's go back to that live.
That's all I have, Detective. Thank you.
Thank you.
Detective Nolan, since we're going to talk about blood, based on your training and experience, did you see any indication that Teresa Sievers was killed anywhere else other than in that kitchen?
No, sir.
Did the blood spatter or lack of cast off indicate that Teresa Sievers was not bludgeoned to death?
Objection calls for speculation.
Well, we just talked about it.
Overruled.
Did your training experience indicate, regarding the blood spatter, lack of cast off, indicate to you that Teresa Sievers was not bludgeoned to death?
No, sir.
Were there any conclusions that you made from reviewing the blood spatter that were inconsistent with the scene as you observed it that day?
With the violent damages to Miss Sievers' head and the amount of blood that was on the ground, I was surprised that it wasn't cast off on the ceiling.
But there was blood spatter in the vicinity of Dr. Sievers?
Yes, there was, and pooling as well.
And that blood spatter and that pooling were consistent with her injuries?
Yes, sir.
Thank you.
But once again, as you told ASA Hunter, you were surprised that there was no cast off.
Yes, sir.
Nothing further.
Is this witness to be released or retained?
He's free to go, Your Honor.
No objection, defense?
He's released.
Okay, you're free to go. Thank you, sir.
And I'd like to approach with number 24, please.
Yes, sir.
Thank you.
Next witness.
State calls Kevin Stout.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Speaking to the mic.
Good morning.
Good morning.
Would you state your name for the record, please?
My name is Kevin Stout. I go by KC.
Casey. And where do you work?
At the Lee County Sheriff's Office.
And how long have you worked there?
Since 2003.
And in what capacity do you work at the Lee County Sheriff's Office?
I'm currently the Digital Forensic Supervisor.
And as the Digital Forensic Supervisor, what is digital forensics?
We basically recover evidence from computers and cell phones, any kind of digital media that we come across.
And have you had training in the area of digital forensics?
Yes, ma'am.
What training have you had?
I got a certification. It's called a Certified Forensic Computer Examiner. It's through the International Association of Computer Investigative Specialists. It's a pretty intense 2-week course that you take in class where they're teaching you the ropes of and introducing you to all kinds of tools and equipment and how to recover data. Once you go through that class, you're assigned a coach, a mentor, and you're given 4 practical examinations where you're practicing how to recover data, how to recover dates and times of files, recovering internet histories. If there's anything that you may have missed or may have not realized how to get that kind of data, your coach that you're assigned helps you through that process. Once you pass all those 4 examinations, you're then pushed on to the next phase where you are given a digital copy of a hard drive, and you then independently recover that same data. You recovered the data in the practicals. You're now doing it as an independent examination where you are running a full examination report as if it's a real scenario. You're recovering deleted data, you're recovering internet histories, the same process that you were in the practicals. Part of that, they throw in a hidden or encrypted file that you're supposed to find and locate and recover, and it ends up being a 100-question test where then you have to pass that test.
And you did all of that?
Yes, ma'am.
And so you are a certified forensic computer examiner?
Yes, ma'am.
Have you had, do you also belong to the International Association of Computer Investigation?
Yes, that's who sponsors the CFCE.
And as part of just that association's membership, are there a certain number of hours every 3 years that you must continue to complete to maintain even a part of that initial membership?
Yeah, to retain your certification, yes, you have to take 40 hours of training specialized in the computer forensics world. Technology changes constantly, so you're constantly having to go to classes. So they require that, yes.
Have you been trained in more than one type of software?
Yes, ma'am.
And have you been trained in the various data recovery companies?
Yes, ma'am.
And it sounds like you've been trained in cell phone data recovery.
Yes.
Were you asked, as part of your duties and responsibilities at the Lee County Sheriff's Office, to examine a number of devices pertaining to the investigation into the murder of Teresa Sievers?
Yes, ma'am.
And let me just start with this. When you receive a cell phone in the digital forensics unit, what is the first step or procedure you use when you are handed a cell phone?
We always want to make sure that no changes are made to the device. So we'll put it inside of a box called a Faraday box, and it blocks all signal from gaining into the phone. So nothing can be changed, nothing can be wiped or anything like that. It keeps it secure.
And once you place it in the Faraday box, are you able to do something to it so that you can then remove it from the Faraday box?
Yes, ma'am. When it's in there, you put it in what's called airplane mode, which you're disabling your wireless connection, you're disabling your cellular connection, and we'll also take extreme measures and you remove the SIM card out of the cell phone.
And when did you receive a cell phone on June 29th of 2015?
Yes, ma'am.
And did you follow the same procedures that you've just described for the ladies and gentlemen of the jury?
Yes, ma'am.
And during the processing of that phone, did you determine what the number of that phone was, the phone number?
Yes, ma'am.
And was that 314-239-0173?
Yes.
Once you had removed that phone from the Faraday box, what was the next step in your processing of that phone?
I hooked it up with a USB cable to a cell phone forensics tool called Cellbrite. Cellbrite's just one of our main forensics tools that we use to extract and copy the data from a phone in order to transfer it to our forensics workstations.
Now, when it copies the data from the phone, does it leave the data in the phone as well?
Yes, ma'am.
So when you return a phone, it's got everything it had in it when you started?
Correct.
And with Cellbrite, can you create reports that put information that's retrieved in a readable format?
Yes.
Tell the ladies and gentlemen of the jury about that.
So after we copy the data, the Cellbrite has a tool where it will parse out all the data, and it goes line by line and categorizes it into, for example, if it sees a line of code where it sees that it's a text message, it'll put it in a text message category. If it's a email, it puts it in an email category. Contact goes into contact. So it categorizes it for you.
And did you perform that? Did you do a complete, what would you call it, extraction on the phone that you were handed when you hooked it up to Cellbrite?
Yes, ma'am.
I'm going to show you what's being marked for identification as State's Exhibit number 25. If I may approach the witness, Your Honor.
You may.
What is State's Exhibit number 25?
It's the cell phone forensics report from Cellbrite.
And is this the extraction that you obtained from device number, phone number 314-239-0173? 0173?
Yes, ma'am.
And is that an accurate, what's in your hand? It's certainly not paper.
No, it's the digital copy that's on a thumb drive.
And so you place that digital copy on a thumb drive?
Correct.
And is this an accurate, does that thumb drive contain an accurate copy of the extraction that you performed using Cellbrite on the phone number with area code 314-239-0173?
Yes, ma'am.
Move to introduce.
Can we approach?
Sure.
Now, they're going to a sidebar, so we're going to take a very short break. But please, you are not going to want to miss our Gavel Gavel trial coverage here on Court TV Live. We'll be right back after a short break. Welcome back to Court TV Live. I'm Ashley Wilcott. Now, we are continuing coverage live of the court case in Florida versus Jimmie Rodgers. Now, we are going to resume with the testimony in this case. This is the 7th witness today. He's with the Sheriff's Department. He's the Digital Forensics Supervisor, Kevin Stout. Let's return to court now.
Please be seated. Who else you calling this morning?
Judge, we have 4 more witnesses in the back for this morning.
I'm going to ask both sides to go through anything you're going to try to move into evidence so we can take care of any issues like this in advance. This should not be a stalling issue, what we're doing right now for the trial. And I'm going to ask over lunch that you do the same thing. We'll be in recess. Let me know when everybody's ready.
All right.
Come get me. I'll be in the back.
Wow. So there you heard the judge say he seemed a little frustrated to me. I'm going to bring in our guests in just a minute. But here's what he just said to the attorneys on both sides. Listen, go through the evidence because I don't want this kind of stall. I want you to go through it and decide what we're going to do. So this is big news because in a huge case like this, when you've got these kind of charges, death penalty on the table, typically you will have addressed this prior to ever starting trial so you know which exhibits you've agreed to, which exhibits you don't agree to, doing any motions before the court. So, gosh, let me start with you, Thomas. What do you think?
It seemed like the state was surprised about that ruling. I think that based on the forensic investigator being the one on the stand, I think he was probably trying to get into the report that he was talking about in the organization and how it organized all the text messages, emails. But he has to do that himself. You can't have a machine just do it all for you if you can't lay the foundation. And so I think that that's what the defense objected to, and it sounded like the judge sustained their objection, which means that they can't get into any of that phone stuff. I mean, I think that that's a major wrench, especially if these text messages and the emails were going to be an essential part of their communication and link to the other 2 individuals.
But there's a way to do that, right? Let's talk about, so how does an attorney do it and lay the foundation properly? Because certainly we've seen trials where you have a phone record and you have this information that frankly is generated by technology. How do you get that into evidence?
Well, you have to go through the experience and background and, you know, what's normally done in these types of situations. And then you have to bring in this particular case and say, well, this is what you've done. And you've definitely moved, you know, in the same manner. And what we also notice is that the judge is frustrated because this is the second time that we were here. You know, we had a sidebar before, and now we have another evidentiary issue. And, you know, ideally, you would want to address those issues before you get to trial. But from a defense perspective, you have to advocate from your client. And if you notice that foundation has not been laid properly, you have to address it immediately.
And, so foundation, from my perspective as a trial lawyer for years, is something you can fix, right? There's a textbook way to lay a foundation to know which questions to ask about your training, your education, and then your work and what it requires and what it entails in each step. So what would astound me is if they can't get these records into evidence, right? So theoretically, let me ask you both, should they be able to get data off of a cell phone, and I'm going to presume it's a defendant's cell phone. We don't know yet. They've already said the phone number. Should that be able to come into evidence from a defense perspective?
The state can do that if they have the right witnesses, but I think that we heard from the supervisor's testimony that he only had 2 weeks of training on this. I mean, he is supposed to be this expert for the state with 2 weeks of training. That just doesn't make sense. And clearly the judge had a problem with that too. And for whatever reason, the state's witness could not articulate the reasons why he believed that evidence was either admissible or add credibility to the report that they were trying to put together, and that he had some knowledge as to how it was put together and how it was coordinated. Without those facts, you can't rely on the automatic report that's generated if nobody on the witness stand can explain that it is what it is.
Okay. All right. So we're going to continue to talk about this case. It's a fascinating case and what's going on. Just a reminder where we are. Court is in a break right now. We know this is the case that involves the twisted romantic relationships, possible financial payouts, and their allegations of a sinister plot to kill Teresa Sievers. Now, Court TV Crime and Justice reporter Julia Janae gets you up to speed on the facts of this case. All right, so here we are back at the case. I want to continue to talk with my guests on this case. And here's what I want to talk about next. You mentioned this as we were talking, Crystal, about the witness prior to this witness. So it's Detective Nolan, the lead investigator in the case. And what I want to talk about, and you pointed this out, the defense brought out on cross-examination, and it was actually re-cross-examination, right? So prosecutor went, defense attorney, prosecutor. The defense attorney got the closing word in this case with a witness's testimony. And the witness did say he was surprised there was no blood cast off on the ceiling. So my question is, so what? What does that mean? Let me hear your opinion, Crystal, on how you would use that as a defense attorney.
Just kind of looking at the defense strategy here, one of the questions that stood out was, could she have been killed anywhere else? And so after that question, that's when we kind of heard the questioning about, what about the splatter on the ceiling? And the expert, the state's expert here, Detective Nolan, made it clear that this was his findings were inconsistent to what he expected. And you jump on that because that the inconsistency definitely creates a reasonable doubt.
And would you take it further? How far do you go as a defense attorney? Because that was not long testimony, right? He was not on the stand for a long period of time. And so I didn't hear the questions asked, and I think that we saw all of the testimony. I know we're there live watching it, and I didn't hear any questions asked about, okay, well, what could affect this? Could the body have been killed somewhere else? Or in the alternative, we know that Wright, who was a co-defendant that pled out in this case, allegedly used the hammer and hit her in the head the first couple of times. If someone else, whoever else, and in this case, the state's going to say this defendant used the hammer, could the force used by different individuals affect whether or not? So are these questions that you all would have flushed out? And let me start with you, Thomas, if you were the defense attorney in this case.
Absolutely. I mean, anytime as a defense attorney, you're looking for things that should be there that aren't, or that the state could not find that should have been there in a case like this. I mean, if you just think about the act of hammering a nail or hitting anything with a hammer, there's going to be blood everywhere if you hit somebody 17 times in that manner. The fact that there was no evidence of that blood spatter in the manner that which the state's position is, this is the way the murder happened, and the evidence just isn't there to back that up, that's a major problem for the state. And from a defense perspective, it looks like the state's trying to put a square peg in a round hole. They're trying to make up something that will stick when the evidence, quite frankly, isn't there to back it up.
Reasonable doubt. Is it going to be reasonable doubt or not? We're going to have to wait and see what happens in this case. Now, please stay with Court TV Live for gavel-to-gavel coverage of Florida versus Jimmie Rodgers. And we are still in verdict watch in the other murder for hire case out of Florida, Florida versus Magbanua. A verdict could come at any time, so please don't go anywhere. This is Court TV Live. We'll be right back.
Welcome to Court TV Live, your front row seat to justice.
And we're doing what we do best and diving straight into our trial.
You have to look at everything in this case.
He murdered our daughter.
Did you take the hose and squeeze it?
Guilty on all counts.
This is true crime all the time.
And you're not gonna miss a moment of it. That was really eye-opening.
This is what I love to do.
Good morning and welcome to Court TV Live. I'm Ashley Wilcott, and we are following two exciting trials out of Florida today. First, we are in verdict watch in Tallahassee. Now, this is the murder trial of Catherine Magbanua and Sigfredo Garcia. Now, the clock at the bottom of your screen is ticking away, which means the jury is hard at work in the deliberation room. A verdict could come at any minute, and of course, we will bring you live inside the courtroom once the jury does reach a decision. Then this case and the fate of these two defendants will be in the hands of the jury. Now, as trial comes to a close in Tallahassee, we're looking at Fort Myers. Now, in Fort Myers, we have day 2 in the Hammer Hitman murder trial, which is already underway. We're on witness number 7. It's on a break at this time. This is the case where 29-year-old Jimmie Ray Rodgers faces the death penalty if convicted of the murder of Bonita Springs doctor Teresa Sievers. This is the case that involves the twisted romantic relationships, possible financial pay, and allegations of a sinister plot to kill Teresa Sievers, the beloved doctor out of Bonita Springs. Court TV crime and justice reporter Julia Janae gets you up to speed on the facts of this case.
In balmy Bonita Springs, Florida, on June 28, 2015, a doctor, Teresa Sievers, was just arriving back home from vacation alone. She planned to go back to work at her busy private practice, but she never made it to the office.
She's dead on the floor, and there's a hammer at the side.
The next morning, police discovered her body and a bloody scene in her kitchen. The 46-year-old wife and mother was brutally beaten to death in an ambush attack. All while her husband, Mark Sievers, and their 2 daughters were states away in Connecticut.
This was a very safe neighborhood.
Her horrifying death shook the community to its core. Questions swirled as her family searched for answers.
It's a very emotional time for everybody. So we just ask, that everybody just keeps everyone in these circumstances right now in their prayers.
With no suspects and few leads, police interviewed everyone, including Teresa's mother.
We both were out in the yard screaming, crying. I guess you can keep me alive now from heaven.
More investigation revealed Teresa and Mark's marriage of 12 years had many layers. Teresa's obituary describes Mark as her loving husband. Friends and family said the couple had typical arguments, often stemming from their shared work. Mark managed his wife's medical office and was a stay-at-home dad. Teresa's practice specialized in anti-aging and holistic care and was inspired by Eastern medicine. But Mark and Teresa's work relationship wasn't the only thing unconventional. Cell phone records and letters recovered by police detailed Mark and Teresa's open marriage, other sexual partners, and a fantasy Teresa had involving Mark's friend, Curtis Wainwright. 11 days after Teresa's brutal murder, a tip from an informant took investigators to Missouri.
I seen like 20 SWAT guys or so, a whole bunch of jackets and flag jackets and a whole lot of rifles.
Their investigation led them to a suspect, Jimmie Ray Rodgers.
Asked us if we see anything suspicious to give him a call.
Rodgers lived in this mobile home park with his girlfriend, Taylor Shoemaker. She would tell investigators Rodgers made an unexplained trip to Florida.
I asked him what he went down there for, and he said to make money. And then asked him how does he make money, and it was murdering Mark's wife. I said, did you shoot her? And he said no. And I I said, then how'd you kill her? And he made a stupid little chuckle that he does and then said with a hammer.
Neighbors pointed to another connection. Rogers was good friends with Curtis Wainwright.
He used to go over to Jim's all the time.
Police arrested and charged Rogers and Wright with Teresa's murder. But for the Lee County Sheriff's Office, the case was not closed. Mark Sievers fell under what Sheriff Mike Scott called an envelope of suspicion. Months would pass and Mark remained a free man, fighting to keep custody of his 2 daughters.
Is this out of control? Yeah, we would say it is absolutely out of control. We've got an ongoing criminal investigation which can and will very likely result in the arrest of additional suspects.
Mr. Sievers, should you be incarcerated, who do you want to have custody of your children?
Then on February 6, 2016, 7 months after Teresa's death, deputies would make their 3rd and final arrest.
I think a lot of people have been waiting for this day.
Mark Sievers was indicted on charges of first-degree murder for orchestrating the deadly scene.
Wainwright, Jimmy Rogers, and Mark Sievers are locked up where they belong.
Life insurance policies worth nearly $5 million only added to the prosecution's case about a sinister plot. Police allege Mark conspired with his friend Wright as early as April of 2015. Then in June of 2015, Wright solicited Rogers to travel with him from Cadet, Missouri to Bonita Springs, Florida. There, authorities say the 2 men caused Teresa's death by blunt force trauma.
Anybody who has a heart is feeling very sad for those children right now.
Rogers and Mark Sievers pleaded not guilty, but Wright turned state's evidence and took a deal in 2016 just before Sievers' arrest. Wright is expected to testify against his 2 co-defendants who both face the death penalty if convicted for the murder of a woman who spent her life helping others heal.
Thank you, Julia, for that great summary of this story. Joining me now to talk about this case, criminal defense attorneys Crystal Ramirez and Thomas Flugum. Thank you both for being here. Now, what a tangled web we weave. This is a heck of a set of facts. If the state proves the case as they've indicated they're going to prove in their opening statement. A couple of things I want to talk about. First, this girlfriend is evidence directly connecting the defendant to this crime and saying, hey, Rogers was involved. I know he was involved. He told me he was. I used a hammer. How damning is that testimony for the defense? Let me start with you if I could, Thomas.
Anytime it's the words of the defendant itself, it's a problem. You know, they don't need any more evidence other than that the defendant, well, let me back up. They don't need any additional witnesses to present the statements of the defendant other than the person that heard the statements. And when something comes from your mouth itself, the words can't be crossed up. I mean, he said what he said to her. Now the issue is going to be her credibility. Is there anything in her background or any reasons that the defense can pull out as to why her statements can't be believed?
Right, and that's a really good point. There's one other piece I want to add, and that is the girlfriend information that she may testify to would include that she said that the boyfriend was known to the police as the hammer, because whenever he could choose a tool or a weapon, that he preferred a hammer. How, again, I mean, that doesn't indicate, does it? And Crystal, let me ask you as a defense attorney again, that doesn't necessarily mean he committed this crime just because a hammer was used.
No, it doesn't. It doesn't necessarily mean it, but it's pretty strong. It is pretty strong evidence. If that's what he's known by, and he has a criminal past that supports it, and we have it here in this case. So that's definitely a strong link. And what stood out about the girlfriend also is this is where the investigation started to open and unravel, because they went to Missouri, had an opportunity to interview her, and then her story was then corroborated by the neighbors. So, it kind of unravels from that point.
Absolutely. I think it does as well. Now, let's talk now about the cell phone records. So we know the cell phone records talk about allegedly this unconventional marriage between the victim, Teresa Sievers, and her husband, and wanting to maybe have other individuals involved, and some of those salacious details, honestly, about a marriage. How important is it that a state, in trying to prove these murder charges, have those cell phone records? And let me ask you that, Thomas, is it really important factually to prove the crime, or rather does it go to a motive?
I think cell phone records in general are always beneficial to get in from the state. But in this case specifically, to me, the fact that it's such an unconventional relationship actually disrupts the state's theory of the motive. Because if I'm a husband and I'm okay with having other partners in the relationship with my wife, then it's going to be tough to convince anyone that I would be so jealous now after having this open relationship that I'm going to hire somebody in to murder my wife because she's showing interest in another man. I mean, clearly, if I'm comfortable with that open relationship and the defense can paint that picture, then to me that almost hurts the state's motive if their angle is that this was jealousy related.
Now, that's an interesting point. So let me ask you, Crystal, do you agree with that? Do you think, or does the jury get caught up? Let's say these cell phone records come in, and let's say they do show that it's an unconventional marriage and there's a third party. Do they get caught up in all of that, and are they able to keep those facts separate from the actual crime and evidence as to who committed the crime?
You would hope that they would be able to, hone in on the relevant factors, but sometimes you never know. And what's in the records definitely important, but depending on what's provided, it can also show location. And without that, and not being able to pinpoint someone at a particular point, at a particular time, that could be very detrimental.
All right. So as we continue through this trial, we know we're on witness number 7. We know the judge admonished, basically, my words, not his, but the two attorneys, and said, get it together, look at the evidence, figure out how you're going to handle the evidentiary issues, because I don't want these stall tactics. Again, my words, I don't want this to stall out the trial. So let's revisit that, because, part of what I think as a trial attorney is you really have to have your rhythm to the case and your strategy, and you need to, and sometimes once you get in that rhythm, if it's thrown off by an unexpected ruling or an unexpected something that happens in the case, your rhythm as an attorney can be thrown off, and you might get thrown and struggle. Do you think that's a potential with the judge sounding the way he did when he said to these attorneys, and let me start with you, Thomas, if I could.
Absolutely. I think that it was a shock to everybody that nobody had brought that up as a potential issue prior to the trial. And from the judge's perspective, here we are, again, on TV, this trial is being broadcast across the nation, and we're having to have an evidentiary argument on an objection on day 2 of a trial when this could be the foundation for the state's case. And if it is, that is a major problem for the state.
Right. So let's talk about in the defense's opening statement in this case. And one of the things, and you all brought it out on your own, and they had also said it during the opening, was, listen, 2 things. First of all, no conspiracy, no money changed hands. You can't prove that. Second of all, they said, look at these injuries that killed this woman, this again, beloved doctor in this community that people knew, respected, trusted. 17 blows to the head. Her skull was shattered. And their argument was, this is a crime of passion. This was not done by somebody who didn't know her or know her well. So, Crystal, let me start with you. How much would you emphasize, rely on, or argue that as the defense in this case?
It's an important fact that you can't ignore. It immediately comes to mind when you hear the facts and you hear 17 hits. It is a crime of passion, but the way that the state has set up this case, it ignores that fact. And so, as the defense, it's important to continue to hone in on the fact that whoever did this did it with passion, and this does not support what the state is presenting.
Right, good point. And I think it's fair to say that often when we see violent crimes, it is a crime of passion. However, we do have to take a quick break right now. There's more ahead on Court TV Live in Florida versus Roger. And again, at the bottom of your screen, the clock is ticking. Could mean that we have a verdict any minute in Florida, and we're going to go to that verdict live when it comes back. Don't go away. You're watching Court TV Live.
As they followed lead after lead after lead. And they slowly began to circle in on two suspects, Curtis Wright and Jimmy Ray Rogers. Over here.
Welcome back to Court TV Live, your front row seat to justice. I'm Ashley Wilcott, happy to be here with you today. Two cases out of Florida that we're covering, and the first thing I want to mention to you is just a reminder, we are in verdict watch. We have a clock at the bottom, 6 hours, 36 minutes, that the jury's been deliberating. At this point in time, they've had 3 questions that have been sent out. The judge has responded to all 3 questions and generally has said, listen, I cannot answer hypotheticals for you, jurors. You all have to apply the facts to the law, and then he will reference them to the page of the jury instructions to look at the definition of different words that they may be asking about. So, such as principle, that's been in more than one of their questions. We're going to keep you updated, and when we have a verdict, we'll be going live to that trial in the state of Florida. Now, what I want to return to is the other trial that we're covering live, and this is Florida versus Jimmy Ray Rogers. This is the Hammer Hitman trial, and this case is in a recess. The judge came and told both of the attorneys in this case, defense and prosecution, look, we've had 2 sidebars for evidentiary reasons or questions. I'm not doing this. You all sort it out, figure it out. We're on an extended break while you do that so we can proceed with this trial without these types of delays. So let's talk about, after the opening statement, the state did begin its case in chief, calling the victim's sister to the stand. And Lisa talked about the last time she saw her sister at a family gathering just days before Teresa's murder. Let's listen.
Good morning.
Good morning.
Can you please state your full name for the record?
My name is Ann Lisa.
And Miss Lisa, where are you from?
Seymour, Connecticut.
And do you know Dr. Teresa Sievers?
Yes.
How do you know her?
She was my sister and the love of my life.
And when you say sister, does that mean that you have a parent or 2 parents in common?
Yes, we have the same parents.
I don't want to be impolite, so I'm not going to ask you how old you are. But were you the older sister or the younger sister?
Older.
And are your parents still living?
My mother is living.
And where does she live?
Seymour, Connecticut.
Let me turn your attention back to the weekend of June 26th, 2015. Where were you that weekend?
I was in New Windsor, New York with my mother, her husband, my siblings, Teresa, Patrick, Frank, and each of us were with our significant others and children celebrating my mother's birthday that had happened previously that year.
And so you were having a family gathering with Dr. Sievers and her husband?
Yes.
And their 2 daughters as well?
Yes.
How long did the family gathering last?
It started Friday, June 26th, around 3 o'clock in the afternoon. And we all departed on Sunday, June 28th, between 12 and 1 at various times, families leaving.
Now, was everybody, we know that the Sievers family wasn't from Seymour, Connecticut, but your brothers and their families, where were they from?
The Sievers family was in from Florida, and my brother Patrick was from Connecticut. My brother Frank came in from New Jersey, and my mother and I came in from Seymour. Well, Ansonia at the time for me.
And how long did the celebration last?
About 2 days.
And what did the family do during those 2 days?
We enjoyed the weather the first day. It was beautiful, and we swam in the pool, and we relaxed in the sun. My sister was doing yoga. She prepared a beautiful dinner, started to cook for the weekend, and we just enjoyed each other's company and had wine and laughed and played a lot of Scrabble because it rained the next day, so we just played a lot of Scrabble and played piano because, much to our delight, there was a piano there and my sister and I played, and we hadn't played in years. So there was a lot of that.
So, and did Mr. Sievers and the Sievers daughters participate in the festivities as well?
We all did, yes.
And when it was time to leave, where did your brothers go?
My brothers went back to their respective homes.
And did the Sievers family go back home to Fort Myers?
The Sievers family left New Windsor to take my sister to a New York airport. I don't remember which one. And my sister from that airport would be flying back to Fort Myers and returning to her home in Bonita Springs. Mark Sievers and his daughters were to be returning to stay with my mother for several days in Connecticut at her home.
And so did Dr. Sievers actually leave New York, leave from New York and come back to Fort Myers?
Yes.
And this was on Sunday the 28th?
Yes.
And did Mr. Sievers and your two nieces actually proceed then to Seymour with you and your mom?
To my mother's, yes.
And the plan was for them to stay at your mother's house, the Sievers, Mr. Sievers and the two daughters?
Yes.
We have to take a quick break, but before we go out, we want to let you know a new episode of Court TV's podcast is out today. This week, Vinnie Politan and Seema Iyer take a closer look at Amber Guyger's sentencing, where 18-year-old Brant Jean shockingly forgave his brother's killer. Now, that was followed shortly by a display of compassion from the judge that uplifted some and angered others. You won't want to miss that on our podcast. We're going to take a quick break. Welcome back. We're going to go straight back to court. The judge is listening to argument by defense and prosecution about text messages and whether or not they're hearsay in the Rogers case out of Florida. Let's go back to court.
That these text messages are admissible, and particularly I would refer the court to what is on page 8 of what I've handed the court. It's on page 1080 of the opinion. So I think, Your Honor, that text messages are admissible for introduction. As to the comment by Mr. Darrow regarding the text message of August 29th, the state's information alleges that the conspiracy occurred between April 30th forward. But that text message is an invitation to a conspiracy, which would be different than a part of the actual conspiracy. And so the state submits that it too is admissible.
Judge, can I respond very briefly?
Sure.
Judge, yes, what the state is saying is halfway there as far as the extraction report being not hearsay. The argument that was made, I believe, by the defendant in Gale was that there were two levels of hearsay, extraction level and then looking at the individual text messages. Gale makes it very, very clear, and so does John Philippe, that just because it's an extraction report doesn't mean it automatically comes in. It just means that there's not a whole other level of hearsay there. It's not hearsay within hearsay. The conclusion in Gale is because the extraction report was not hearsay, and because the state established an exception to the hearsay that was appellant's own statements, we affirm the trial court's submission. So very key in the Gale decision is the fact that there has to be an exception for the content to come in.
Okay. Any other things that you're looking to introduce that we're going to have a problem with the other witnesses coming forward that we need to address before I go read the Philippe case?
Your Honor, not today. And we have provided to Mr. Darrow the other specific pages from another extraction that is not being introduced today, Your Honor. At least it's not the intent of the state to call that witness today, so that Mr. Darrow would have an opportunity to review those pages before the next court date.
After this issue is resolved one way or the other, how much time do you have left with this witness, and who's next, and how long will they take?
I'm sorry, Your Honor. Would you repeat that?
Irregardless of the ruling on this, how much time do you have left with this witness on the stand? Who's next, and how long will they take?
Your Honor, I have, I was going to say about as much time as we've used up to this point, but that provides the court no information. At most another 15 minutes. That might be a more accurate way to phrase it. So probably another 15 minutes with this witness. Our next witness is Deputy Armato from the Lee County Sheriff's Office. He will be a brief witness. The witness following him is Gladys Martinez. She was part of the crime scene that went to autopsy and recovered items from autopsy. Those have been shown to the defense before now. I mean, they were shown to the defense during the break, so they're aware of those items. And then we have, I believe, Lieutenant Downs testifying. All of the items that would be referenced to him have been brought into the courtroom, and during the break, Ms. Fitzgeorge and I went through each of those items. Okay. And you still have withdrawn your motion on 25. We're just dealing with 25A and those particular texts that were extracted, correct? Yes, Your Honor, I withdrew it at that point because if 25A, yes. I'm asking because we were talking about two different things, right, even though we were only recessed on one. Right. What I'm saying by withdrawing it is if 25A is coming into evidence, the state will withdraw any attempt to introduce 25.
And my guess is that 25 is the whole extraction. So what I'm saying applies 100 times from this to that. Well, that's the complete extraction report, correct? Correct. Okay. All right. Give me a little bit of time to go read the other case you just have given me.
Thank you, Your Honor. And Your Honor, as always in any case, the state would submit that 25 is admissible, but what goes back to the jury is different than what is admitted in court. So the state did not seek to have State Exhibit 25 go back to the jury. Rather, just to have 25A go back to the jury. It just makes clear that that came from that extraction. Yeah, 25's a thumb drive, right? Correct. Right, okay, yeah. Exactly.
I really don't want the jury back there with a thumb drive.
Well, they have no way to access it because I don't give jurors computers, and that's why I'm trying. And I don't let them take them back there either, so I was just making sure I got it.
Right.
Okay. I'll be back. All right.
All right, we're going to talk about this. Let's delve into what just happened. A lot to talk about. So first we heard the defense say, listen, these text messages, and mind you, we don't know exactly who those text messages are between. So the defense says these are hearsay. There's no exception. They're not admissible. The prosecution obviously says, no, they are admissible. They should be allowed to come into evidence. So let's talk about that piece first. Does it make a difference? And I know this is let me start with you, Thomas. Does it make a difference as to who the texts are between?
Absolutely it does. So as we mentioned earlier, an admission is any statement by a defendant that he makes to somebody else. So all the state has to prove is that the defendant made the statement to the person, whoever is testifying. Now, with these text messages, there's additional layers. First, as we kind of highlighted earlier, there's the extraction piece. The witness who testifies to the extraction piece has to be able to testify to how that was done, that nothing was altered, etc. Now, the other piece here is if these are between either Mr. Rogers or one of the other co-defendants, a statement by a co-defendant is not admissible against another co-defendant unless that person is testifying. And so that's, I think, the issue. They have separated that Mr. Rogers and the other individuals' trials, and so now they can't get into the statements that those two would have made together. Now, Mr. Wright, the guy who coordinated the whole thing, if they brought him in to testify to those statements, that would cure the issue, especially if he was one of the ones coordinating the two and the statements are between him and Mr. Rogers, then the state would be in business. But to your point, we don't necessarily know who those are between. And if they don't have anybody who is one of those two people receiving or sending the text messages, then they're not going to be able to get those in, I don't think.
And I think you raise a really important point, which is we have to keep in mind, you cannot use one statement against the defendant against the co-defendant, right? You can't do that. So let me ask you, Crystal, I know the prosecution also said, listen, the August 29th text, that specific text, it was an invitation to a conspiracy, not part of the actual conspiracy. Is that a valid argument, or is that just splitting hairs?
You know, I would argue it's not valid. We're talking about relevant. And if you're trying to get it in and say, hey, it's an invite. It's not necessarily getting to the issue, but it's an invite. And so you want it to come in, but as a defense, you have to continue to hone in on the flaw, which is that it's not an actual text message involving the conspiracy. Which is very important. And what's interesting here for me is the perspective. The defense perspective is, you have the extraction and you have the actual text messages. Okay. And the state's perspective is, hey, the extractions they come in, and so everything comes in. But that's not enough. You have to be able to show that both are reliable, the extractions and the individual text messages, whatever they may be.
And I think that's why it's so important to cover these trials live, because all these little technical pieces, as lawyers, you're required to know how to do that, or else you're not going to get your evidence in. So let's talk about that part, and that is getting the evidence in and this judge and his demeanor. So my read of the judge is that he's aggravated, annoyed, whatever word you want to apply, in terms of, you all haven't worked this out. I want to know exactly what to expect, how much time you're going to take, how many witnesses you have, what are the issues with any of the evidence for the rest of this trial so we can resolve it now. Is that practical, Thomas, from a practice standpoint as a defense attorney?
The judge's job is to be the umpire. And from a defense attorney perspective, this is a death penalty case, and I need as much time as I need to explain the evidence, regardless of the judge's opinion on how fast or slow this stuff should take. Now, I think the flip side is, they've been in court since 9 a.m. They broke at 10, and the judge is having to break till after lunch. So you have a group of people who are sequestered in this room for 4 hours, not hearing any of the evidence in the case. And as a judge, I think that could equally be his frustration. We have brought these people here. They're out of their job. Their job is to decide this trial. And you guys haven't sat down and figured this stuff out. So we keep having to take breaks while these 12 people are sitting in the jury room just twiddling their thumbs.
Right. And to that point, isn't this something that theoretically, again, I go back to this, it is a murder trial, death penalty on the table, right? So to me, there's been discovery, there's been all the information, all the exhibits that the prosecution intends to introduce, the defense should have ahead of time, not right there while they're sitting there, unless it's, just newly discovered evidence, which is a whole different issue. And so these things they should have known ahead of time, right? Am I wrong, Crystal? What's your takeaway, or what do you think about how this is playing out?
It's definitely things that should, you would have a gauge on ahead of time. But when you are actually in the moment and that trial is playing out, if you see that there's an issue where the evidence is not being properly, there's not proper foundation to get this evidence in, as a defense attorney, you are obligated to address it, despite the feelings of the judge and despite, the demeanor of the judge and how he wants this trial to go. You have a duty to your client, and if you see the issue, you hone on it. And the other issue is, considering the opening statements, right? That's your roadmap, and you tell the jury, both sides, what the evidence will show. This is a big deal because it establishes credibility. So if you don't get this evidence in, the jury's not aware of what's going on. If you don't get it in, it is an issue of credibility because you told the jury that this was going to come before them, and it never comes.
And then sometimes they may focus on the one little thing they didn't hear versus the 99 things that they did. So we are going to have to take a short break. Again, just reminding you that the court is in a break in the Jimmy Rogers case. We're going to come right back here on Court TV Live.